This is Jewish Spotlight, a weekly television program presented by Chabad Lubavitch of Long Island, featuring various aspects of modern Jewish life and Jewish culture. Now, here is your host, Rabbi Tuvia Teldin.
Shalom. It's that time of year again, and of course, Jews all over the world will be celebrating Hanukkah in many, many different ways. But at the same time, while we celebrate Hanukkah, and here in America we celebrate with great religious freedoms and abilities to do wonderful things that we haven't been able to do perhaps in many countries during Jewish history. However, the question arises, what exactly are the rights of religion? In a free society, in a society where there is protection from establishment of any particular religion as the religion of the country. And as a result, Lubavitch in particular, who has been very active throughout the world in setting up public menorahs in places from Venice on the gondolas to be able to have a beautiful, beautiful menorah overlooking highways and in city squares and for public officials all over the world. There's a question as to what exactly are the limits of the rights of setting up these menorahs in public places. And of course we get to the question of separation of church and state. And this has been a very lively topic of discussion, a lively topic that's come into the courts in many different formats throughout recent past. As a result, I wanted to delve into this a little bit, as we are in a little bit of the spirit now, to talk about what exactly is this separation of church and state, because it doesn't affect just the observance of Hanukkah or the placing of public menorahs in government areas. It also affects many, many different aspects of our life, as we will soon find out. In order to delve into this a little bit more, in order to interest you in this topic, because it's something that I think you'll find really opens up a world of understanding much about our history as a nation, both for Jews and non-Jews alike, I asked a specialist, a constitutional lawyer, a person who's a professor of law at Touro Law Center. It's my pleasure to have with us Professor Tom Schweitzer.
Good evening.
Professor Schweitzer, it's a pleasure to have you with us at the Jewish Spotlight.
It's a great pleasure to be here.
So I have a question. I've heard about constitutional lawyers in the past, and of course I've always looked with a certain amount of great respect as to a person who dedicates her life to understanding our Constitution. I'm a little bit of a constitutional lawyer myself, but the Constitution that I study is the Torah, and the Shulchan Aruch, which is the code of Jewish law. But there's such a fascinating wealth of information that you have about going into exactly the meaning of the Constitution, how it applies to our life. Before we get into discussion of separation of church and state, I'd just like to hear a little bit of your background in terms of what brought you into constitutional law and what do you find so fascinating about it?
Okay, well, I think as a law student, I certainly enjoyed constitutional law, which is a required course. Later on, in practicing for a large law firm in New York City, I worked on the area of aid to religious schools, which poses issues of the law of separation.
Obviously, right.
And there are those who are opposed to this as unconstitutional. The Supreme Court's jurisprudence is a little bit confused, I would say, in this area, but they have permitted certain kinds of aid and not others. Later on, when I began to teach, I have taught First Amendment law, and now I'm teaching a course called Law and Religion, which is a section of this area, based on the First Amendment, Establishment Clause and the Free Exercise Clause. You want me to recite those? Or,
That's okay, but well, I'll tell you what, let's go into the Establishment Clause, because that's really the basis of what we're going to be discussing today. What exactly does it say in the Constitution, and what is the basis upon which they wrote that into the Constitution?
All right. The Establishment Clause is at the beginning of the First Amendment, the beginning of the Bill of Rights enacted in 1791, and it states, Congress shall make no law respecting an establishment of religion, and it goes on then to the Free Exercise Clause, or prohibiting the free exercise thereof.
Okay.
And there had been religious conflict, of course, in Europe, a lot of religious oppression, persecution, and some of the early colonists fled that to come to America before the United States was created. There were established churches in a number of colonies, but there was a trend in the late 18th century to end that establishment. The last state to get rid of its established church was Massachusetts in 1833.
So the state itself actually had an established religion.
That's right, because the Constitution, the provision says Congress shall make no law, so for a long time that was understood to permit the states to have establishments, but not the federal government.
Interesting. Now, of course, these days, and I don't want to jump ahead to the present too fast, but just to give us a little perspective, based on that Establishment Clause, of course you have two completely extreme opinions what that means. One person will say that this means that it only prohibits the government from establishing a particular religion as a religion of the country.
Right.
Others will say that it creates a wall between church and or religion and society and government, whereby there shouldn't be any religion, any mention of God, anything at all mentioned in combination of the two. So we see, of course, a very, very extreme difference in interpretation. How over the years did it develop to create such a dichotomy of views?
Well, the jurisprudence, the case law, dates from after World War II for complicated technical reasons which I won't go into. But even in the Supreme Court itself, there are sharply differing views. The justices argue and they don't persuade one another. So there are those who, as you said, don't think that it's okay to be favorably disposed to religion in general, as long as obviously you can't have an established church. You can't have favoritism for one religion. But
that everybody agrees to.
That's right.
And everybody, I think, agrees there has to be some wall between church and state.
That's right. But you can't have a total wall. I mean, if a church or synagogue is burning down, are you going to refuse to send the fire department to put the fire out, or
Good point.
deny them water and sewage service? And you know, there really is no way to separate religious bodies entirely from the larger
U.S.
society.
currency. You have in Garvey Trust.
Currency,
You
right.
have chaplains saying prayers before the opening of the Senate or the House of Representatives.
That's right.
So it's a very cloudy area. Sometimes it seems to me that the Supreme Court almost likes to keep it cloudy, because either they're afraid of taking a stand, or else they don't know themselves what exactly would be the right position to take.
Well, as I said, there certainly have been sharply differing views within the Supreme Court, and some people might say, "In God We Trust" should not be in our currency. But
really, there has been a movement for that, or
there was a lawsuit, yes.
Really?
And you know, you may not know, Christmas is a federal holiday in this country, which of course has obviously religious significance, but it's considered a secular day also.
Right.
There have been challenges to the laws which used to require everybody to close their business on Sunday, Christian or not. That's obviously the Christian day of rest, and but Jews and other non-Christians were bound by it.
Let's go back to back in history to a few cases that were tested, let's say, in the 1800s, early 1900s, things that we might take for granted now, but really had to go through a whole process of establishment clause, you know, where we're going to draw the line with the guidelines from there. Let's say, for instance, you had mentioned something about having to put your hand on the Bible in order to be able to testify.
Yes.
Something as simple as that.
Well, and to become a public official, you had to swear an oath on the Christian Bible, which Jews conscientiously could not do. So they were effectively barred from public office in a number of states. And in
barred from public office because of that?
Well, but as a practical matter, they were unwilling because of their religious
So they could have been elected
practice.
as a public official, and they got to that point, and then just been disqualified as a result.
That's right. Well, because they would be unwilling to take the oath. But in other cases, in New Hampshire, I think it was after the Civil War, before Jews were permitted even to run for public office. 1860s or 70s, I forget exactly, but they were barred, and there were Jews who were called to testify in court on a Saturday, and which they couldn't do, and they asked to be excused or for postponement, which was denied.
Right.
There were laws against blasphemy, and just one instance where a Jew in the 1600s was accused of violating blasphemy because he said Jesus Christ was not God. But for some reason, he was never tried or convicted, so that ended.
That was before the Constitution.
That's right. That's right. Yes.
Interesting. Now, we go a little bit closer to our period of time. Of course, we have a major controversy about exactly what this Establishment Clause is. You have many organizations working on both ends to convince the world of their opinion, or at least to convince the Supreme Court. The Mortimer issue comes up in the 1970s, largely because of Lubavitch, the organization which went around and established its menorahs in various places, and public officials were willing to have it, may even checked with their legal staff and said, okay, it's a gray area, but we can do it. Yeah. Can you give us a little bit of the history of the development of that? Because it is, and you know, even from a legalistic perspective, a fascinating study of how the different courts throughout the country dealt with that particular issue, until we've come to the point today where, for all practical purposes, there is no fight about it any longer. It's perfectly acceptable behavior, but it gives us a case study of something that's gone through the system and had to fight in order to be able to show its right. So what are some of the previous case histories, if you could share with us, to give us an idea of how this developed?
Okay. Well, I think, to my mind, the core of the Establishment Clause is that the government cannot play favorites. It can't endorse one particular religion and show any favoritism vis-a-vis others. I think that if you display a menorah in a public park or other public place where other groups could apply for permission to have their symbols displayed. I don't think that's an endorsement of Judaism. It's just making a public forum available. And maybe the most extreme example of that, in a sense, was when the Pope came to Washington, D.C. and said Mass, religious service on the Mall, which is almost like the nationwide commons. And that was challenged in court. And they said, no, it's okay, not unconstitutional, because any other religious group, if they applied and posted a bond and so on and promised to clean up, could get the same permission. So in many cases...
Isn't the law today, though, that there has to be, let's say, when I set up a menorah in some place, there has to be also a nativity scene or something from another religion to counterbalance, and so it should seem like a governmental endorsement of one over the other.
That's right. I mean, but I'm not sure that's an absolute requirement. Certainly that has been present in a number of cases. There were, U.S. Supreme Court took cases involving Christian nativity scenes, creches, from Rhode Island, and in one case they said it was okay because there were reindeer and a babbling brook and candy canes and things which are really not Christian symbols, they're winter symbols. And in the case in Pittsburgh, which the American Civil Liberties Union challenged, the menorah was upheld. I think you might disagree with this because they said it was not a religious symbol, and I don't think that makes sense. But there was a Christmas tree there too, but the nativity scene was struck down. This is in the city
Right, and
hall.
that was a famous case.
Yes,
right.
In 1992.
Correct. Right. Now, let's talk about another issue which has come up recently and has caused a tremendous amount of interest, and that is prayers in public area. Let's say as far as at a football game or other types of situations which are student-run, that students, I believe, have the right to have their own organized prayer, but it can't be something in any way coming from the administration of the school. Can you give us a little background on that also?
Well, there again, I think the central point is that the government, through the public school system, cannot endorse a particular religious belief or viewpoint. But the origin is cases in the early 60s which challenged Bible readings in public schools and school prayer. One of them came from Long Island, New Hyde Park. When I was a student in public school in the late 50s and early 60s, I would recite the so-called Regent's Prayer, which was non-denominational, but it mentioned, it was a prayer to God, and it was struck down as unconstitutional in 1963. It took another almost 30 years for someone to challenge prayer at graduations, because that's only once in a student's lifetime instead of every day in class. But that was struck down in 1992.
That was a case right here in Babylon, I believe, in Long Island.
No, this was, I'm talking about one from Rhode Island. And ironically, there was a rabbi who gave the invocation, and it was a Jewish plaintiff challenging the constitutionality of that. And,
interesting.
And actually his older daughter graduated from the same school and was subjected to a Christian prayer. And so he protested, but they wouldn't stop it. But then they said, well, how about a rabbi? And then his reaction was, I didn't want to get squeaky wheel treatment. I didn't think there should be any clergyman or prayer at a public school graduation. But then this, just recently, the Supreme Court has held that prayer at football games, under the circumstances of the case, was unconstitutional. But you're right to suggest that if the students want that themselves, and they're sponsoring it and taking the initiative and not the school authorities, that some courts have held it constitutional. There's a division there.
Now, let me ask you a question. Are we getting so oversensitive about having any presence of God mentioned in our midst? I mean, first of all, there's a question whether or not God and religion should be the same thing. Religion is a personal practice. Belief in God is something that can be common to all peoples and all cultures. So have we turned into a society that is so nervous about the presence of the name of God that we have to do everything possible in order to keep it away, that it might hurt us? What's going on over here? How has our legal system developed to the point where we're afraid of the name God?
Well, I mean, the legal system hasn't really gone that far, but some maybe teachers misapplying the jurisprudence might do that. I've heard of students who wanted to write about God in an essay for a high school class and were slapped on the wrist. That's an unacceptable topic. But
so in other words, they can write in school about every possible idiocy you can imagine. They can use any type of four-letter word you can imagine. They can wear on their shirts everything you can imagine. But to talk about God or to do something that has to do with the Bible, that is not permissible.
Well, the Supreme Court has never said that, Rabbi. They have acknowledged that religion...
Straighten me out.
religion is part of history,
Okay.
and they don't want to adopt an ostrich attitude where you would ignore the importance it's played for good and ill in our history. So they recognize that it's a appropriate subject of study for
but
religion.
Professor, let's be realistic. In history classes, how much is the Bible used as a textbook or even as a resource in order to discuss history?
I'm sure very little.
Very little.
But certainly you can't study European history, just to take one example, without talking about the wars of religion, religious persecution, conflict. And I understand that there are textbooks used in American high schools which dumb down things. For fear of controversy, they really downplay the issue of religion. Of course, they don't mention the word God at all. I understand the Pilgrims, who were original settlers in Massachusetts, who came to flee, they fled religious persecution in England. They are referred to as people who made a long journey, really kind of distorting and oversimplifying the reality.
Didn't George Washington say that in his opinion you could not take God and religion out of democracy, or else democracy would not work?
That's right. He said that religion is necessary for morality as well, and I think that most of the Founding Fathers just assumed a belief in at least a generic kind of Christian religion. Some of them were members of particular Protestant denominations. There were no Jews who signed the Declaration of Independence, one Roman Catholic. Both of those groups were very tiny in number, I think 1/10 of 1% at that time. So
even Roman Catholics at that time?
Yes,
really?
In 1790.
Interesting.
So the vast majority of people were from Protestant backgrounds, mostly English descent, some Dutch and other ethnicities. But almost everyone was Protestant or from that background. That was sort of taken for granted.
Interesting. Let's go back to some other different types of cases. Kosher laws. Of course, you've had that knocked down in New Jersey. You've had it knocked down in New York. Can you explain to our audience what is the basis behind, number one, the kosher laws, the way they were established in the beginning, and number two, why they were knocked down?
Well, I think that the kosher laws were an effort to accommodate people who wanted to only eat kosher food, and it's almost like a truth in packaging measure. If you buy something which is purportedly kosher, you deserve to get what you pay for. Consumer protection, exactly. And for many years, they were upheld as constitutional. They had been challenged over the years, going back. Yes, around the World War I period, I found a case in New York where it was challenged, but it was upheld. But one of the problems is that the government has to deal with the Orthodox rabbis who define what's kashrut, and so that was attacked as an entanglement, in quotes, between religion and the state.
Right, and, otherwise, how do you have consumer protection, though?
Well, indeed. I mean, and I think that most people probably don't find anything objectionable about this. No one's required to buy kosher food, but if you buy it, you want it to be authentically kosher and not pretend. So I think that might have been wrongly decided. But there's a problem when you have an entanglement between the church authorities and the government authorities. And obviously, the secular government doesn't know what's kosher and what's not kosher, so they have to be educated by Jewish authorities.
So in other words, any time that the government has to come to religious authorities for some type of knowledge, that's considered to be entanglement.
Well, that might be overstating it, but when they have the religious authorities who take part in the decision-making process, and the government's, in a sense, delegating its power to a religious body, that might be a red flag. This is a little bit off the subject, but there was a case in Massachusetts where a house of worship of any faith could prevent a bar or other kind of establishment from being established within 1,000 feet of the place of worship.
Like a school.
That's right. And that was struck down because it gave the religious group too much power over other legal, secular
Interesting.
operations.
What if it would be a parochial school?
What's that?
What if it would be a parochial school? Like a public school also, it cannot have a bar within a certain amount of...
Is that a law, I suppose?
I don't know if it's a national or state law, but I'm pretty sure a lot of zoning laws have that incorporated.
Yes, yeah, I think that would be upheld. But here was the defect was that the religious body had the power to veto what would otherwise be a legitimate enterprise. So in the Supreme Court's view, that rendered it unconstitutional. And by the same token, when you have Jewish experts saying what is kosher and what's not, and regulating the enforcement of the kosher law, then that bothered the judge in that case.
Interesting. Very interesting. Now, can you tell us very quickly also about the Monroe case.
Oh yes, Monroe Woodbury, upstate
Right.
New York, Orange County. Yeah.
Orange County, concerning
Catskills.
the establishment of a separate school district in order to be able to treat those children who were either learning disabled or disabled from the Satmar Hasidic community in that
Yeah.
area. Also,
Yeah.
a fascinating case, and the case, of course, that was in the courts for many, many years, and he received
It's
a
been up
tremendous
and
amount
down.
of press.
Yes, indeed.
Right. But again, let's talk about that from an educational perspective.
Okay.
This is entanglement because they're establishing a different district, or what exactly is the problem here?
Well, I have to
They're
say,
taxpayers themselves, so if they be
yes.
paying taxes for one district or another district, what difference does it make?
Yes. I have to say that when that case was decided years ago, I spoke out against it and gave a little talk. So I think it was wrongly decided. But what bothered the Supreme Court was that the New York State Legislature, which parenthetically is not controlled by the Jews, established a school district specifically to benefit the handicapped children in the Satmar Hasidic community in upstate.
Right.
And it was coextensive with the Satmar community. So 100% of the residents of this particular school district were Orthodox Jews. It's not that they kept out non-Orthodox Jews or non-Jews. They were the people who lived there, and they ran their school district democratically. It was a public school. They didn't have Jewish insignia on it, but the Supreme Court said it was unconstitutional because it was establishing a public school entity district on religious grounds.
Interesting. Now you get here, of course, into a greater issue than just the specifics of these types of cases. And of course, it's really almost coming down to, in some people's perspective, especially for the people who are in the extremes of both viewpoints,
Yes.
to almost a cultural battle.
Yes.
A battle of the heart and soul of America as far as whether or not America is going to be, quote-unquote, godless or with God. Not that the people who are separationists, who don't want there to be anything connected to or between church and state, want the world to be godless either. It's just that they feel that politically or constitutionally it should be separate.
Yeah.
But I think there's a deeper argument here. Now, I don't know if this comes up in legal circles as far as what exactly is the process going on here. What is the motivation behind the people who are fighting on both ends? What is the driving force of why sometimes in the extremes in particular there's so little room for compromise? Is there any discussion about this, or what is your feeling about it? Is there really, do these two issues really, or the two viewpoints in this one issue, really represent to a certain degree a cultural war going on in America?
I think you could call it that, but I feel that most people on both extremes are sincerely believe in their viewpoint. And one of the problems is that the text of the Constitution is very succinct, very terse, brief. And so you have to put flesh on the bare bones. And sometimes you go back to saying, what did Thomas Jefferson and James Madison intend, the founding fathers, the framers of the Constitution, in the 1780s or the 1790s? And it's frankly very difficult to figure that out. And of course, they weren't the only people.
Well, why is it so difficult? That's what I don't understand. Why is it so difficult when you have so much of their writings and they make it so clear that they themselves were religious individuals, that they only said that there shouldn't be an establishment of a religion?
Yes.
So why is that so hard to interpret?
Because one of the problems is you have to apply it in the public schools. There have been many cases involving the schools. There was no system of free public education in the 1790s.
Right.
So they're applying this problem to a current reality which didn't exist 200 years ago, and we were left to speculate about what Thomas Jefferson might have thought.
Right, but that's the process of law. You're always speculating in terms of how to apply it to specific situations. But the basic tenet of the separationists, that there shouldn't be any mention of God, let's say, in the public view or in government at all. I don't see what the source of it is, especially if you try to look into the minds of the founding fathers, who themselves were very religious people, who have many of their writings publicly recording the fact that they felt that God was an important part of the world.
That's right, indeed, and Thomas Jefferson among them. He did refuse to issue proclamations of Thanksgiving because he thought that was too religious to be appropriate for the president. But he did things like asking Congress to appropriate money to pay a Catholic missionary to teach the Indians, now violation of church and state. So certainly he and even James Madison didn't have the same understanding as the Supreme Court separationists have today.
Right, but it's so interesting, you know, what you mentioned about the Jews, let's say, and Roman Catholics being such a minority going back to those days.
Yes.
So it puts it into a little perspective, the tremendous change and evolution of religion in America over the course of these years, as far as the development of tolerance and the need for tolerance.
That's right.
In order to be able to keep this country together, the E Pluribus Unum, of course we have
Indeed.
tremendous unity now, much more than they had back then when the E Pluribus Unum was a basic statement of our country.
That's right. And of course today we have Hindus and Muslims, a lot of other
sure,
non-Christian
sure.
groups which were very scarce in the old days, very rare.
50 different religions represented in
Sure.
America.
Yeah.
Just one other issue also, speaking of public schools, as you brought up, of course our organization has been a strong proponent of a moment of silence in
Yes.
public schools.
Yeah.
Which again, I understand back in the days of Thomas Jefferson, they weren't prepared for issues like that.
Yeah.
But of course, the concern for many of us in the Jewish community is that if there would be an actual prayer said, that the prayer would most likely, or I should say, possibly lead to becoming a Christian prayer. However, a moment of silence, or a denominational prayer.
Yes, right.
However,
right.
a moment of silence leaves the students themselves to be able to think and pray as they would like to be able to pray. Now, the concern, of course, of those who are opposed to the moment of silence is that a moment of silence is quickly going to turn into a real prayer.
Yeah.
But again, you get that slippeage, what did you call the slippeage?
Slippery
the
slope.
slippery slope, that by doing one,
Yeah.
you're going to automatically lead to another. And that seems to me to be so much a part of the problem here, that everybody is so afraid that something is going to give a little bit that nobody's willing to be flexible.
Yeah. I mean, frankly, I think some of the decisions outlawing a moment of silence are ridiculous. I always tell my students, as a father of young children, sometimes I think a little bit of silence is good for kids now and then. And it doesn't necessarily have to endorse any particular religion.
Mm-hmm.
They can pray quietly. They can think of baseball or some other non-religious topic. That's right.
It doesn't have to be religion or God.
I just think some of the judges who struck these things down are going off the deep end.
Professor, one last question. What do you think about having the Ten Commandments up in public schools?
Well, it's been held unconstitutional. Certainly it's something which Jews and Christians would agree on. I suppose there are slightly different formulations, but it was above the blackboard in a public school in Kentucky, and the Supreme Court said it was unconstitutional as an endorsement of religion.
One of those things that you're never going to understand. Okay. In any case, Professor, it's been fascinating. We've covered a lot of ground. I hope that everybody's learned a little bit about how pervasive this whole Establishment Clause is for everything that goes on in our society in so many different aspects of our life. So it's been a real pleasure having you with us, and I wish you much success in your teaching and hope you continue to share constitutional law with many people. In the meantime, enjoy the holidays and go out there and celebrate the fact that we're in America and we're in a place where we can really be free to establish and to live our religion as we would like to. And that's really something that is so special. So we should look forward to a wonderful year, a year of health, a year of happiness, and a year of many good things for everybody. Take care, shalom, and keep up the good work. We'll see you next week.